Good afternoon, LGL 130. Welcome to part 4 and 5 of our lecture. Today we're going to talk about amending the Constitution and the POG power and the interplay between sections 91 and 92 of the Constitution Act 1867. And I'm a little pressed for time today. As you can see, I'm in my office, so I don't want this to go too long, so let's get going. So amending the Constitution is very difficult in Canada. It is generally seen as one of the most difficult constitutions in the Western world to amend. It is an entrenched statute, as you know, so when something runs afoul of the Constitution, it loses its effect. So again, this is most often manifested in charter jurisprudence when someone points to a provision in the Charter of Rights and Freedoms and says that that law is unconstitutional, or another law like the like the Criminal Code of Canada should be made unlawful because the Charter of Rights and Freedoms it runs afoul with the Charter of Rights and Freedoms. So that's sort of where unconstitutionality of a law most often comes up. So if we wanted to amend the Constitution, let's say we wanted to get rid of the Charter, we would have to do that in a very specific manner, and that's coming up shortly. So if you will pull up the statute itself, you will see, and you might be able to do that on your screen, you'll see that it is actually quite difficult to do. So let's go through the slides here. Okay, amending the Constitution. So let's look at Section 38 through a general amending formula. This is largely the big one. This is the one that most people discuss of when they talk about amending the Constitution. The general amending formula, it involves... Okay, sorry about that. I just had to pull the Constitution up. So the general amending formula is just the general amending formula. So that's sort of the big one, and it is very difficult to do. Section 42 lists matters that are subject to the general amending formula. So this is, the principle of proportionate representation of the provinces, the House of Commons, powers of the Senate, the method of selecting senators, the number of members which a province is entitled to in the Senate, Supreme Court, subject to paragraph 42D, the Supreme Court, and so on and so forth. So those are the big ones. That's the big one, and it is very difficult to amend. Certain provisions from Section 41, and let's move to the next slide, slide 29. Section 41 has to be done by unanimous consent. And so what are those? Unanimous consent. Those are mapped out as well. So the office of the Queen, the Governor General, Lieutenant Governor of a province. So if Canada were to seek to become a republic without a monarchical head of state, currently Queen Elizabeth, then we would have to have unanimous consent. So the amendment of the Constitution of Canada relating to the following matters may be made by proclamation issued by the Governor General and the Great Seal, and so on. So that is a big one. Those are a big one. Just certain largely ceremonial, super constitutional offices like the Queen has to be done by unanimous consent. Makes sense. You don't want a Republic of Alberta with an elected president and a monarchical Ontario, right? So you wouldn't want that. Amendments relating to some but not all provinces is found in Section 43. Okay, so if the proposed amendment only affects some but not all provinces, then you just need to involve those provinces. So example being changing the name of Newfoundland to Newfoundland and Labrador in 2001. That was a constitutional amendment that involved Newfoundland and Labrador. So it just involved that province. And then the next, the final two, 4 and 5, and they're on slide 30. Those are federal unilateral amendments, so it falls squarely under the Parliament of Canada's powers as they are enumerated in the Constitution. Then that is sort of constitutional amendment can be made at the federal level alone. And similarly, if it's enumerated power by for a province in section 92, then that province can make unilateral amendments. Both of those, I can't really think off the top of my head any examples of when that happens. But anyway, it is a difficult constitution to amend, and it is a very important document. As you know, the Constitution primarily found in three documents: the Constitution Act 1867, Constitution Act 1982, which has within it third the Charter of Rights and Freedoms. So those are the amendments. Let's now move on to the interplay between the provinces and the federal parliament and the POG power. So what is the POG power? The POG power is found in section 91 of the Constitution Act 1867, and that is a space where well, let's take it back. Remember, Sir John A. Macdonald, the first Prime Minister and one of the primary forces behind the Union of Canada, then Canada West and Canada East, and the maritime provinces of New Brunswick and Nova Scotia, eventually PEI, and then eventually, much later, the Atlantic Canadian province of Newfoundland and Labrador. Anyway, you remember the Prime Minister wanted a unitary state for all of Canada. They looked to the south in the United States Civil War, the breakup of that in 1961, or 1861, excuse me, and they they didn't want to emulate that. So what happened is that there was this idea in Section 91 of the Constitution that that the federal parliament would make laws for its enumerated areas, but also for the peace, order, and good government. So it would basically sort of follow up with anything past that. And the provinces were really just left to their own devices with what they were given in Section 92. And it didn't really work out that way for a number of reasons that we're not going to really get into. But it was one of those, those things that was a big sore spot between the provinces and the federal parliament. And we talked about Oliver Mowat, and the great lawyer, politician, who argued his own cases all the way to London. But let's come back. So nowadays we have the POG power exists in three parts, and that's sort of the gap or the residual branch where the Parliament, where the power is not specifically allocated, but it goes to the federal Parliament. We got the emergency branch. Excuse me. Laws of a temporary nature, such as the War Measures Act in the past or the Emergencies Act now, although I'm going to save talking about that because I don't, there's been a lot of talk with the Emergencies Act, but I just don't know enough about it at this time. And then a national concern branch where, a matter is clearly of a national concern, and that's the aeronautics or atomic energy, where, it's just much better to have Canada looking after something rather than the provinces. So, okay, let's move forward here. Conflicts between heads of power. Going back, we've always had the courts to step in, and so there was sort of, constitutional protections for the courts and the judiciary as a third branch of government in Canada have existed for a long time, because they have, since almost the beginning of the country, been called upon to adjudicate between conflicts between the various levels of government. So the conflicts are there, and they're not as there now so much. Although the levels of government interacting is what we're really seeing through the COVID-19 crisis. So it's been very interesting to watch. But basically, principles have developed over time to resolve conflicts between the various federal and provincial powers. And so these have found their way into doctrines, legal doctrines, And the 5 of them that we're going to look at is colorability doctrine, the necessarily incidental doctrine, the double aspect doctrine, the paramountcy doctrine, and the interjurisdictional immunity doctrine. So let's just look at those there from the beginning. So what happens? First of all, when you're dealing with sort of something that could be a conflict, right? You look at what is called the pith and substance of the legislation. What is it really about? What is it really intended to do? So a good example of this is to go back to the late 80s and the conflict having to do with abortion. Okay, so and this is sort of an example drawn, from a real situation, but we'll just keep it hypothetical for now. Okay, let's say that a province maps out, it wants to create or at least it says it wants to create a framework where women have to, before they are given an abortion, they have to go and get a number of conditions met. They have to meet a number of conditions. So they have to, talk to a healthcare provider about the long-term effects of abortion. They have to talk to, their spouse or whatever. They have to do, they have to have a checklist of things. Okay, and what is the pith and substance of that legislation? Well, often, maybe, again, we're keeping it hypothetical and we're in sort of a learning environment here, so we'll just, we'll do our best to keep it hypothetical. But is the pith and substance of that legislation to actually stop abortions? Or is it to actually provide sort of healthcare services? And so if it is there to stop abortion, and it's a provincial law, then obviously we've crossed over into the jurisdictional powers of the Criminal Code of Canada, and so we've got a problem. So anyway, when we look at the validity of a conflicting statute, we firstly look at the pith and substance of the legislation. What is it really there for? So from there is from that we go on really to the step is to determine as to whether the statute is valid. So if in the pith and substance of the statute it falls within the legislative jurisdiction of the government passing it, then it isn't really a problem. But if it is ultra vires, if it goes outside of the jurisdiction of that level of government, then we have a problem, right? So that's it. Sorry, I just saw a little mistake. I just moved the slides out of order. So after slide 35, if you could go forward to the colorability doctrine and the necessarily incidental doctrine, we will just carry forward there. So colorability doctrine, okay, this is triggered when the stated purpose of the legislation appears to contradict the actual purpose, okay? And so using that abortion example, there's it is right there. Crown and Morgentaler. So the famous Morgentaler cases was, Morgentaler was charged under the Provincial Medical Services Act, okay? And so the court ruled that the purpose of the act was not stated as it was, but instead was to legislate criminal matter relating to abortion under a federal head of power. So that was found to be ultra vires. The stated purpose of the act, which was to deliver high, quality health care, disguised the intended purpose of it, which was to prohibit abortions. So the colorability of the legislation, that's sort of what it is. Okay, and then next slide down, talk about the necessarily incidental doctrine. This will allow some infringement by a federal or provincial government on a head of power belonging to the other, but only if it does not go to the core of the power, okay, the core. So it must be incidental to the overall purpose. It can't go to the core of it. The technically invalid part of the legislation is held to be valid because of close relationship with the larger valid scheme of the legislation. So, yeah, the necessarily incidental doctrine. There can be some crossover can't go to the core. Okay. Double aspect doctrine. Okay, so this allows for laws to be created by both the federal and the provincial parliaments in relation to the same subject matter. If it's possible for each law to operate without conflict or inconsistency, they will be upheld in the double aspect. Okay, so both laws are a valid exercise of the power for each level of government. So this, an example here for me, don't do it as much anymore, but Parliament has the power to create federally incorporated corporations, and so does the province. So the Business Corporations Act of the Ontario and the Business Corporations, or the Canada Business Corporations Act of the federal government, again, they do very much the same thing. There are different costs relating to incorporating, but they're both allowed to do it. So that's sort of the double aspect doctrine. The paramountcy doctrine is where there is a conflict or inconsistency between valid provincial and federal law. The federal law will prevail. The federal law is paramount. Okay. The provincial law will be inoperative to the extent that it conflicts with the federal law, but it still may be in force despite the inoperable sections. And if the federal law is later repealed, then the provincial law will begin to fully operate once more. So I think of it, and I don't know if this is a good idea, but I think of it as sort of a, the provincial power, if the federal power is removed, it'll bounce back. Okay, it'll bounce back into effect, and it's sort of dormant or sleeping if once there's some crossover with the federal parliament. Yeah. So, and okay, so when you see two valid statutes, so again, they're both intravirus, they're both within the head of power of the respective level of government. The ones you look at, double aspect and paramountcy, those are how that's how you sort of settle the matter. So moving to slide 41, the test of paramountcy. The federal and provincial laws were validly enacted in relation to the division of powers under the Constitution. So they're both found to operate okay in acceptable parameters within the Constitution. Compliance with both laws simultaneously is not possible, either because the operational conflict or because the compliance with the provincial law frustrates the purpose of the federal law. So, okay, sorry about that. I just had to think through. So yeah, when you're testing the paramountcy doctrine, so is it can it happen? So they're validly created laws, okay, but it's not possible to simultaneously comply with them. Then sort of you put the provincial law to sleep. And the interjurisdictional immunity doctrine, where there's overlap, that federal power is protected if it is a vital or essential part of the basic, minimal, and unassailable context of the constitutional head of power. So they're different because they don't have to touch. So basically, let's look at Quebec and the Canadian Order of Pilots Association. So it's a provincial law dealing, Quebec, touching a core federal competency, that is aeronautics, and the provincial law was a serious law, but okay, I just did a pause there because I wanted to recall GTA versus Mississauga. So basically, GTAA, the Greater Toronto Airports Authority, is a quasi-government. It's quasi-government or is it private? Anyway, It's an organization that runs Lester B. Pearson International Airport in Mississauga, not Toronto, in Mississauga. Mississauga had some development fees, okay, and they wanted the airport to pay, and I can see why they would want that. Airports, there's a lot of money found within the airport. But because the aeronautics, the constitutional provisions, the head of power, the head of power, it is a federal head of power to deal with aeronautics, okay? This is not enumerated in Section 91 of the Constitution Act 1867. This came along later in the 1930s case, the Aeronautics Act. This was basically the courts deciding that very much in a way something new came up, and this was of a national importance, and that was aviation. You don't want 10 different aviation authorities or Transport Ontario dealing with aviation. You want Transport Canada dealing with aviation, because there's so much back and forth between the provinces. Just an example, the most some of the busiest flights for Air Canada are from Toronto to Montreal. They're not to Ottawa, they're not to Sudbury, they're Toronto to Montreal, and of course Toronto, Vancouver. So much Pacific bound traffic heading out that way. So, the Aeronautics Act decided that it would be a Dominion responsibility aviation. And we've talked a little bit about that because, it was the federal government that closed down aviation on account of COVID-19. But so anyway, so it just, there was immunity because of the federal immunity against the Mississauga development fees, because it was aviation was of a federal head of power. Okay, so I'm going to stop there. Read the books. If you have any questions, please let me know, because this is a complicated subject. It is a complicated one for me to teach too. Honestly, it's not something I do every day in here at my office. So we'll just hold that off. But just if you see that over the corner right there, that is a piece of the Berlin Wall. It was my uncle got it when he lived in Warsaw, Poland, and it's up beside my legal diplomas because lawyers, what we do is very important. So have a great weekend. Sorry, this is a little muddled. This is pretty much the toughest one we'll do. But if you want to look at questions, please look at page final thing. Page 118 and 119. Short answers 1, 4, 5, 6, and 9. Discussion 2 and 5. I'll take those up at the beginning of next week. So thanks. Have a great weekend. Talk to you soon.